this juncture, since counsel for defense has concluded their closing argument, we'll go back to counsel for plaintiffs to see if they're having a rebuttal closing argument. Counsel for plaintiffs, you can have a rebuttal closing argument, and if so, please feel free to proceed.
Thank you, Your Honor. Trying to figure out which one is better. The podium.
If you're at podium, you don't need the pocket microphone. If you're going to walk, we'll be glad to use it.
I'm here this, okay?
Oh, thank you.
Do you need the side shelf up, counsel?
Well, I'm trying. The only reason I'm going back and forth is just because of the binder, the way the binder sets up on the podium. I want to start off, ladies and gentlemen, with where Mr. Odou left off. And I may go back here because fortunately the way
You turn that on.
Sure.
Did you have a lapel on? No,
I do.
lapel. Is it turned on?
Oh, let me see. Oh, now. Perfect. I'll start again. I want to start off where Mr. Odou left off. He said, no one suspected to find hydrazine. You heard those words? And as soon as he said that, first I was writing it down, but as soon as he said that, I thought to myself, you're right, no one did. And the reason why Real Water didn't is because Real Water never tested. From 2006 to 2020, the only thing they tested for was bacteria. Did you hear him ever say that we did the GMCS testing? Never. It's not like we found some unknown chemical. The chemical is right there identified in the CDC's list of toxins. Don't act, for some reason, Real Water would have you believe that hydrazine was some mystical chemical that no one ever heard of, any scientists, chemists, doctors, no one. It just came to light on the day the FDA decided to test it. That's simply not the evidence. Hydrazine is among several toxins known long before Real Water decided to make its product. And that's why the CDC found it. They just did a standard GMCS test and found hydrazine in the water. That was it. For him to suggest that it wasn't reasonable to test, ladies and gentlemen, he's asking you to completely ignore every witness you heard who talked about customer complaints, the lack of QC, the lack of QA. That's what he's asking you to ignore. That makes no sense. When you consider, and I want you to hear the testimony of Mr. Anthony Randolph. I want you to hear his testimony. Can you put that up? I want to put this in context right up front.
Did there come a time in the fall of 2020 that you became aware that there were a number of people getting sick?
If it's regarding why I'm sitting here today, yes, I do.
Okay. And did you have a discussion with Mr. Blaine Jones about that?
I did.
And did you tell Mr. Jones about these people getting sick that you heard about?
Blaine Jones or Brent Jones?
Blaine Jones.
I did have a conversation with Blaine Jones.
And did you discuss the possibility of a recall with Blaine Jones?
I did.
How can Mr. Odou say, in the one hand, the comments of myself, Mr. Kemp, and himself are not evidence, and then have you ignore the true evidence, the testimony from their own internal person who's begging the vice president to do a recall? How is that not noticed? He said, right before he said no one suspected hydrazine, he said customer complaints are not noticed. He said these complaints were not notice of hydrazine. He's asking you to skip over whether or not there's a notice of something is wrong. It doesn't have to be that they said in the customer complaint, I found hydrazine. You don't expect the customer to go out and test your water for you, do you? No. When the customer says, I smell something like gasoline, or a chemical smell, or I've been sick in the hospital, or my husband's been sick in the hospital, I've been throwing up, vomiting, diarrhea, how can that not be noticed? He would suggest that you would simply ignore it. Because they did not say it was hydrazine, it wasn't noticed that there was hydrazine in the water. As if he expects the plaintiffs here to go and test the water for them. Why doesn't he expect them to market and do the commercials too? And I say that kind of tongue-in-cheek, but it was their obligation to test it. Before they put it on the market, it was their obligation to test. Now he says that, and this is another weird position for Will Water to take, and I do want you to use your common sense. I've never asked you to throw that out the window from the time I met you. He says that Dr. Najm indicated that he had two possible theories of how this hydrazine was introduced to this real water product. And he says no one expected it. Again, Dr. Najm didn't expect it. Well, when you have a brand new product and you're using a brand new way of making it, why doesn't that tell you, perhaps I should test this brand new product before I put it on the market? Give an example. And we've all seen this driving around Las Vegas. They've had the driverless vehicles in Vegas. And you've seen them probably. They test them before they actually put people in them. You've heard of airplanes. They test them, brand new airplanes, before they put them on the market. They chose a brand new, bizarre way, using Mr. Kemp's word, of making water and decided, I'm not going to test for known toxins. I'm just going to do a bacteria test. And when complaint after complaint came in, they never changed their approach. They just gave away more toxic, poisonous water. That's what Real Water decided to do. Shane, show me slide 32, please. I started here right before lunch with this graph, this timeline. And I wanted to start in 2008 because that's when Blaine testified that they didn't do any testing from 08 all the way to 2020. We know they never did it even in 2006 in terms of known toxins. And then I put each of these customer complaints on this timeline. If you could go to slide 34. 34. And you can see in this slide, now we have more customer complaints. We got Susan Dorn's customer complaint. We have the 2017 NSF audit. And we also have the failed NSF audit in 2018. We also know that Mr. Watkins, who's in the hospital, that happened in May of 2018. If you could, Shane, go to the next slide on this one, which is 40. And you can see here, ladies and gentlemen, all of our clients' dates imposed on this timeline. Look at all the notice they had before any of our clients got sick. All of the hospital time. If they'd done something in 2008, of course we would have never gotten to 2014. But all of these customers got sick along the way. Even Mr. Blaine Jones got sick. And after Mr. Blaine Jones got sick, Anthony Randolph told him, stop it, recall, pull the water off the shelves. And right after that, you see our clients getting sick. Myles Hunwardsen got sick in 2019, but 3 of the 5 was before that. Ms. Brody was 2018, again, after the 2 failed NSF audits. I don't know how you could not say notice. That screams notice. And Real Water knew it when they said there was no notice. I mentioned this a little bit right before lunch about Mr. Blaine Jones and his ability to change his deposition if he felt like it. I also mentioned that he could come here and testify and explain his comments about $10 million, which he chose not to do. Additionally, he could have come here and explained why he refused to do a recall when his own employee, Anthony Randolph, salesperson, is telling him, vice president of sales or director of sales, telling him, do a recall. Not only you, but 3 of my friends got sick. How could that not be noticed? How could that not be conscious disregard? That's the timeline. Could you go to 42, please?
That's the same thing.
Okay, thank you. Ladies and gentlemen, after, and I said this before, last night I'm sitting up trying to figure out how to kind of put it all together. And really, part of that was how do I summarize all of this for you and allow you to make decisions based strictly on the evidence and trying to remove my own opinions from it. It's hard to do. But I wanted you to think about this as I finish up. This is a quote I found, and I'll tell you who said it after I finish it. It's very short. I have one life and one chance to make it count for something. My faith demands that I do whatever I can, wherever I am, whenever I can, for as long as I can, with whatever I have to try to make a difference. And when I saw that, I said, man, that sounds similar to how I started this process with you, ladies and gentlemen. That was from Jimmy Carter. And I said, you know, I found something. I looked through, you wouldn't believe how many things I looked to find something that would capture this moment, in my opinion. And hopefully that helps, because we have put something extraordinary in your life. And the money is one thing, because that's the only thing we can deal with given our system. The message behind punitives, to me, is where the difference is made. I didn't want to squander this opportunity. Mr. Kemp didn't want to squander this opportunity. We only have one opportunity for our clients and trying to prevent this from ever happening in the future. And so in looking at what Mr. Carter said, I thought to myself, what would Real Water suggest to this jury? And obviously I didn't write this all of this while Mr. Odou was talking. I wrote this last night. And I said to myself, and I'll read it to you. These are my thoughts in terms of what Real Water would come back and say. And I start off by saying, I would like to consider the reality of not holding Real Water responsible for punitive damages. That's, I think, is what Mr. Odou is trying to do. It says, if you don't award or find Real Water responsible for punitives, it's if you're sending this message to Real Water and to others. It is okay not to investigate customer complaints. It is okay not to test after customers have reported health problems. It's okay to not have a qualified QC person or a QA employee. It is okay to not stop production when employees are getting sick from consuming your products. It is okay to put profits ahead of safety. That's what Real Water is asking you to determine. That's the message that Real Water wants you to send. That it's okay to do all of those things. And I just can't believe, after hearing this evidence, that that's the message this jury wants to send. These plaintiffs are hoping that, based upon this evidence, you find that Real Water consciously disregarded their safety. More than just these plaintiffs, however, are listening to this message. The world will hear your message. And I want you to do what Jimmy Carter said in his quote, and I'm so happy I found it. make a difference by sending the right message. And the only other thing I want to talk about, because I had to say it because I was surprised that Blue Water said this, involves my plaintiffs generally. Mr. Alsina did not spend the time to meet with a single one of these plaintiffs. He didn't do an examination. He didn't ask to do some kind of interview, nothing.
Objection, facts, non-evidence.
Sustained closing argument.
Instead, he offered a one-paragraph opinion. And in that opinion, can you put that opinion up? This is what he says. The effects of concern with mycophenolate are for conception for women as the drug crosses the blood barrier and that the available clinical evidence does not indicate an increased risk of malformations in the pregnancy when the father was taking mycophenolate. Dr. Alsina doesn't tell you what drug he should use as opposed to mycophenolate. He doesn't explain what these malformations are as opposed to birth defects. He's telling you and is telling Mr. Hunwardsen that don't listen to the UCLA doctors who've already prescribed what medications you should receive. Don't follow the UCLA drug protocol or the
Objection, facts,
transplant.
non-evidence.
Can you all approach briefly, Madam Clerk, for turn on white noise, please?
So it's,
Parker, can you turn that microphone?
Yeah, sorry, we asked him to
Sorry,
turn off
we're
the kind
torturing
of
you.
bench. Council, can you
Is that on?
put that slide back down, please, for a quick second? And then, council, can you both
It's on.
reapproach, please, for a quick moment?
You don't, it doesn't matter.
Well, it's okay, leave it off for a moment anyway, because I have to have it.
okay.
And council, I understand you're withdrawing, so the court need not rule on?
Yeah, correct, that's correct, John.
Okay, go ahead.
And so at this point, Dr. Alsina's statement talks about mycophenolate. So I want you to see what mycophenolate says one more time. Go to the slide, the mycophenolate warning, please. Males who have female partners who are able to become pregnant should also use effective birth control before and during treatment with mycophenolate capsules. Talk to your healthcare provider before starting treatment with mycophenolate capsules about birth control methods that may be right for you. Big yellow warning. We know Dr. Hudson has made it clear that Mr. Hunwardsen can choose to try to have a baby, compromising his health for 3 months, and potentially having children with birth defects. Or he can protect his own life and continue on the mycophenolate and tacrolimus. That's the evidence. This is the evidence. Dr. Alsina's position does not comport with UCLA's medical advice and treatment of Mr. Hunwardsen, Dr. Hudson's advice, his opinions, and even the pharmaceutical company's information. Again, we appreciate all the time and effort, ladies and gentlemen, you've devoted to this case. And we do want you to use your common sense. And we do want you, of course, to look to this evidence, both the testimony, the documents you've seen. And if you do that, and in our opinion, truly consider all of the notice the real water received, given that timeline, we find the punitives, we hope that you find the punitives unnecessary to send the message. Thank you very much. Have a good afternoon. Appreciate it.
Does that then conclude the rebuttal closing arguments by plaintiffs?
It does, Your Honor.
Okay, appreciate it. Pardon?
I just asked him to make sure to turn off the.
Oh, no, bring it to you.
No worries. Pause for one quick second.
You're welcome.
Appreciate it. Thanks so much.
Thank you.
Okay, ladies and gentlemen of the jury, you've now heard the conclusion of all the closing arguments. That means the next step is deliberations. Before I go to deliberations, you probably remember when I was reading the jury instructions, that it talked about how 8 of you in a civil case, and that you need to have 3/4. That was one of the many jury instructions. Now comes the difficult time where the court has to ask the clerk, and in each case it's different, we don't know who's gonna be the alternates, is who are gonna be the alternates in this case. And you can appreciate why we always have alternates. Life happens, okay? Sometimes different things happen during the course of a trial, and so you need to always have extra potential members of the jury here in order to ensure that we always have the appropriate number to go back for deliberations. So in just a moment, after I thank you all, my clerk is going to say who are the alternates selected for this particular case. Now, what we do with alternates is a couple of different things, okay? So in a moment, I'm going to read the aspect about it's going back to jury deliberations, and those jurors who are going to go back for deliberations are going to go back to the jury deliberation room. They're going to have the exhibits that we talked about in the jury instruction. They're going to have the verdict form that's prepared for your convenience, copy of the jury instructions, etc. Now, with regards to the alternates, once we find out who those alternates are, they have two choices. They, of course, cannot go back to deliberations at this point. Sometimes alternates want to go on with their lives, right? They want to head at home, okay? Now, as long as somebody stays within 20 to 30 minutes until the jury has concluded its deliberation, that is perfectly fine, and we let people go on with their lives. Of course, I have to read the admonishment, and it's so very, very, very important that anyone who is an alternate has to abide by that admonishment, because what may happen is once the jury starts deliberating, either the jury goes to conclusion of deliberation with the 8 that originally go back, but if for some reason one of those jurors or more than one cannot deliberate right through the ending of the deliberation period, we would call various alternates back, and those alternates would then participate in the jury deliberation process. And what would happen is the deliberation process would stop, and you'd have to start from the beginning with the deliberation process, because you have to have the same 8 individuals who deliberate the entirety from basically start to filling out the verdict form. Everybody understands that concept, okay? So the hard part is you are a wonderful jury. I know everyone would like to keep all 12 of you, but we can't under the rules. And so therefore, in just a moment, my clerk is going to do that. And what she's going to do is my wonderful JA who just walked in is going to take charge of the alternates. And she's going to ask the alternates whether or not they wish to stay or whether they wish to go back to their houses. Of course, you leave the notebooks on the chairs, right? With the caveat that if you have to come back, you need to come back, start from scratch, and of course the admonition. So very, very important. You can't discuss in any matter. You have to agree to do that as well. And then we'll swear in. The marshal will then take charge of the jury to bring back to the jury deliberation room, which has got a nice view, although today it's not as nice and clear that you can see all the way to the mountains, but you can still see part of the valley, so it's nice view back there. So at this juncture, without further ado, Madam Clerk, can you please state who our alternates are in this case, please? Very, very appreciative. I mean, you all have been great. Multiple days of juries, or jury questioning, multiple days of trial, and sometimes it's a disappointment to possibly be an alternate, maybe coming back. So for those alternates, I need you to make sure, and I'm going to, JEA is going to be sworn in just a second. Let me read the admonition first, and then she'll swear in our JEA to take charge of the alternates. So ladies and gentlemen who are the alternates, during this recess in which you are the time period you are viewed as alternate, you are admonished you must not talk or converse among yourselves or with anyone else on any subject connected with the trial. You must not read, watch, or listen to any report of or commentary of the trial or any person or entity connected with the trial by any medium of information, including without limitation social media, text, tweets, newspapers, television, internet, radio. Anything I've not stated specifically is also included. Do not visit the scene or the events mentioned during the trial. Do not undertake any research, experimentation, or investigation. Do not do any posting or communications on any social networking sites or anywhere else. Do not do any independent research, including but not limited to internet searches. Do not form or express any opinion on any subject connected with the trial. The case is fully and finally submitted to you if you're called back as a seated juror. And what can happen is, my JA will mention to you, is that basically she'll say you can call the next day or two to see if the jury has concluded with its determination, okay, whether or not you need to get called back. So I need a verbal confirmation by each of the alternates that you will abide by the admonition of the court. Can I just get a verbal statement?
Yeah, John.
I appreciate it. Thank you so very much. I think it's both names. Sorry, my apologies. We just wanted to make sure your check was correct. That's why we were double checking last names. Can I just get a verbal confirmation for you as well, please? Yes. Appreciate it. Can I get a verbal confirmation for you? Yes. Appreciate it. Can I get a verbal confirmation from you as well? Yes. Do appreciate it. Okay, so this juncture, Madam Clerk, can you please swear in JEA to take charge of the alternates?
You do solemnly swear that you will keep these alternate jurors in some private and convenient place, that you will not permit any person to speak to them unless it is by order of this court, so help you God.
I do.
Appreciate this juncture. Of course, out of courtesy, we always Rises of alternates will be going on the J8, and please leave those notebooks on the chairs. Thank you so very much. I do mean sincerely, this jury has been a pleasure. Thank you so very, very much. Make sure you take your belongings with you. Watch your step while you put there. Okay. Thank you so very much. Okay, now at this juncture, we might as well stay standing for a moment because what's going to happen, our wonderful clerk is going to swear in our marshal to take charge of the 8 of you who will go back to the jury deliberation room. Madam Clerk, could you please swear in the marshal?
You do solemnly swear that you will keep this jury together in some private and convenient place, that you will not permit any person to speak to them nor speak to them yourself unless it be by order of the court, except to ask them whether they have agreed upon a verdict, and that you will return them into court when they have agreed so help you God.
Yes.
Okay, so before the marshal takes you back to the jury deliberation room, sometimes the question comes back is how late can you deliberate? What generally happens is the marshal will check up on you a little before the 5 o'clock hour to see if you wish to continue to deliberate past the 5 o'clock hour or whether you want to come back the following day. And if it's basically, it's, the decision of the group of jurors what you wish to do as a collective group. Because you can come back tomorrow if you do not wish to stay past the 5 o'clock hour and continue your deliberations. We'll put you back in the jury deliberation room, and then whenever you're done, we'll come back. And other people like to continue to deliberate later past the 5 o'clock hour. So that's going to be up to each, to all of you as a group to decide that. With that, thank you so very much. Marshal, you've already been sworn in. Please take the jurors back to the jury deliberation room.
Okay.
And in a few moments, we'll get you the instructions. Yeah, please do take your notebooks with you. And the jury instructions, the verdict forms, as well as the exhibits, and a laptop will be provided to you shortly. The marshal will bring that back to you shortly. Thank you so very much. Okay. So counsel, have you had a chance, you may not have had a chance yet, you had a chance yet to give our wonderful team, clerk or court recorder, a phone number where you maybe reached a business card or something, one for each side, so that they can reach out to you when the jury comes back?
I think we're just gonna stay outside.
Oh, you think you're gonna stay outside? Okay.
I can do
Just in case, because sometimes
Ma'am?
people say that, yeah, of course you can. Sometimes people say that, and then you decide you might do something differently, so we always do get a name and a contact phone number of somebody who actually whose battery is charged and will be picking up the phone. You might chuckle, but he's been there, done that one. I mean, thank you so much. And Councilman Ruble, I think you're doing the same right now. Okay, so counsel, do you all want to take the 15-minute afternoon break and then come back and argue the potential punitive damage instruction, or would you prefer to wait to see what the jury does and then it's from the court standpoint, the court can address it at either juncture. I just want to see what you all would like to do. The court in no way is taking any advance ruling, as you know, by just willing to hear it. I'm just asking you timing-wise when you want it heard.
I'd rather be prepared, Your Honor, argue it now.
Your Honor, did we give you a courtesy copy of our bench brief? I think it got lost because the marshal was out.
I printed him about 6:30 this morning.
Thank you.
Yes, he's in.
Anytime at the court's convenience is fine.
Okay, so why don't we do this? We've got to get all the exhibits and everything back to the jury, so let's go on a break right now. I'm going to say 20 minutes, so that 25. But we need the laptop first before we go off the record. We need confirmation that the laptop is clean and approved by both sides, please. Is the laptop approved by plaintiffs?
Yes, Your Honor, it's one code by us.
Pardon? I asked plaintiff and I heard defense voice.
Eric Pepperman for plaintiffs, yes, we approve the laptop.
Councilman Finch, you had an opportunity to review the laptop and it's approved by you as well.
Yes, Your Honor, we did.
Thank you, Mr. Godfrey. Feel free to approach. Mr. Parker, can you make one step to the side? Thank you.
Thank you, Your Honor.
Okay, so then the clerk has the laptop, and she's going to hand the marshal the various items that we already went through, i.e., and that laptop has an appropriate drive interface, so it can do to the data.
Correct, it has a USB interface. It does not.
Mr. Godfrey, okay, so it has USB interface. Are those,
We have,
they're USB plug, okay. Okay, we're good, okay. Appreciate it, thank you so very much. Clerk's gonna hand those to the marshals, then we're gonna give you a break, and then do you want to come back at 3:20 to argue the issue with regards to potential instructions? Does that work, everybody?
Yes, Your Honor.
Council Plan, somebody?
Yes, Your Honor.
Okay, appreciate it. So we'll leave off the record while you go get that taken care of, and the marshal takes care of bringing it to the jury. Appreciate it. Thank you. To stay under that current situation, or do you wish to keep your alternates in order? Here's your first alternate. Or what, if anything, you wish the court to do, or to address that later on in the afternoon, depending on how late you're here. The court has no preference, I'm just giving you a heads up.
I think we should stay at least till 5, and then we can pick it up again at that point in time. Because she is the first one.
That's why the court was mentioning who it was. Okay. Does that meet the needs of counsel for real water?
Yes, it does, Your Honor.
Okay, thank you so much. Okay, so can you all, do you have the proposed two versions of the jury instructions? I know your bench briefs mention them, but can I actually see the proposed jury instructions, the two alternatives that you're asking the court to resolve? Does somebody have those?
Yes, Your Honor, I realize I did not have them with me, and so we're working on printing out the copies to provide those for you right now.
Okay, well, is it, okay, well, let's try a round two way of possibly doing this. Is the page 5 in the defendant's brief, brief on punitive damages during instructions starting at line 8/9 through line 16, the complete accurate of what plaintiff is proposing?
Yes, Your Honor, my recollection is that the jury instructions are both the exact same except for the one phrase about in light of the defendant's financial condition.
Is there a way, do you have a copy of defendant's bench brief?
Right here, Your Honor.
Okay, guess I'm saying, can you look at page 5?
Right here, right here.
No worries, somebody's right here. Okay.
That's right.
I think defense might have another copy, because remember they're
No, we got
in
it.
court.
We got it.
So what I just was confirming is, since I don't have a copy of the actual instructions, if you all say, yes, Your Honor, page 5, starting between lines 8 and 9 to line 16, other than the emphasis added, because there actually is no emphasis added, but that that's what's being proposed by plaintiff, and then being proposed by defendant and something different by plaintiff. I'm trying to get the scope.
It's everything after the comma. Plaintiffs put a period after the word deterrence.
That's what I'm asking, okay.
That is correct.
Okay, so the only distinction is whether or not the word's taking into account the defendants, and that, this is in a plural, because there's two real water entities, right?
Right.
Financial conditions, that's the only distinction between this construction that you're asking the court to resolve?
Yes.
Councilor Plaintiff, do you concur?
Yes, Your Honor.
Okay, I just want to make sure,
You can have mine for me, please.
okay, so. Here's, now I've had the opportunity to hear the closing arguments, but here's a question the court has had. Because the way you all did your bench briefs is you did them a little bit differently, no surprise. One was focusing on a more industry in the second part of the language with regards to deter future conduct, and the other was saying it needs to focus on the individual. But where the court needs to get a better understanding of, in defendant's bench brief, they proposed that the language from Brent Jones, that there was basically a $9 million testimony that he stated that either get played or that get read to the jury. But I wasn't clear from plaintiff's bench brief, and I realize these are bench briefs, right? But from plaintiff's bench brief, whether or not they were disputing that that was evidence, or the argument just was that defendants can't say that they're bankrupt. So I just need a little point of clarification, so the actual argument is clearly presented to the court. So I'm kind of paraphrasing what the issue is. I think the fair thing is I give you each one round, because this is not a motion or anything, it's, right? That work? Okay, go ahead.
Yeah, it's evidence, of course, but it's not relevant evidence because in this case, the punishment is not at issue. And the reason the punishment is not at issue, there's two reasons. One, when they say this, we quote it, they say they're a dead and bankrupt company. So punishment is not an issue for that reason. The second reason is we have agreed in stipulation bankruptcy court, we attach the bankruptcy order, that we will not seek to, I think we attach the bankruptcy order, if not, we're quoting from it. But we have agreed that we will not seek to collect the punitive damages award against Real Water. So Number one, they're not a viable company. They're a dead bankrupt company. Their words. And two, there's no way that this punishment is being sought against them. So that's the reason that financial condition is not relevant. So what they want to do is they want to go pretend that there's some sort of punishment and pretend that they can't pay it and attempt to minimize it for that reason. And I think this Ace Trucking case that we cite is right on point. You know, it talks about the annihilation offense, that's the term it uses. It says, this is without a bankruptcy and without an insolvent company. It says that the rule is very restricted and that the rule is available only in clear cases where the defendant is being wiped out. Okay, that is not this case because like I've already said, number one, they've wiped themselves out, and number two, we've agreed that we're not going to attempt to collect it against them. So what they're really doing is they're really presenting a situation of the jury that just isn't true. They want to go back and use the 2019 and 2020 evidence. They haven't been in operation in 21, 22, or 23 because the FDA consent decree basically put them out of business since they couldn't satisfy it. So for that reason, Your Honor, there should be no consideration of financial condition in the jury instruction. Now they cite this Philip Morris case. I think that case has absolutely nothing to do with this because first of all, Philip Morris dealt with a situation where there was punishment and the consideration was whether you could consider out-of-state plaintiffs in deciding how much to punish. So the court said under the due process clause, you can't use punitive damages to punish a defendant for injuries inflicted out of state. Like I've already said, there is absolutely no punishment here in the first place, so we don't get to that. But Philip Morris also said that you could use out-of-state conduct to consider reprehensibility. So in the Philip Morris case, what they're entitled to is what they call a Philip Morris jury instruction, which is you can consider out-of-state conduct for purposes of reprehensibility, but not for punishment. That's what Philip Morris says. They haven't even asked for that instruction, and it wouldn't be applicable in this case, Your Honor. So for those reasons, we don't think the jury instruction should reference financial condition at all. You know, this is a pure deterrence situation, Your Honor.
The court's got a couple questions, okay?
Okay.
Hypothetical, one of them hypothetical question. Okay, when I was looking through this, right, and you're looking at the status of the specific defendant and where they are. So, I'm gonna pop this in a hypothetical. Hot dog vendor, right?
Mm-hmm.
On the sidewalk, okay? So what do you wanna call it, mom and pop, pop and pop, whatever, okay? Little rolly cart hot dog vendor.
Jimmy Rose in 1960 on Rancho in Charleston.
That might be.
Maybe.
That was a few years before my time, but I knew of it.
You've
Okay.
heard of that.
So that versus, okay, so whatever happens, it said hot dog cart, right, okay? The mustard's got some issue in it, I don't care, ketchup's got some issue in it, or a hot dog or the bun, whatever the case may be, you know, someone chips a
Hot dogs
tooth.
are a month old.
Yeah, or chips a tooth on the stale bun or whatever. Okay, so they've now moved to a different corner, no longer in business, right? The person's a little hot dog vendor, whatever. Filed bankruptcy, it really doesn't matter for my purposes of my example. Does Oscar Myers well come in on that case? And that, the reason why is, I was trying to think of the rule here for where you're saying is if you're taking into account that you can't punish, right?
Mm-hmm.
That, how does that go
Insurance.
across? Right. It's got two purposes, I appreciate that. It is deterrence, but there's an and in there, right?
Well, it's actually an or. And I'm reading your instruction to make an example of or.
Excuse me, I meant to say, it's an or, but are you saying that
There's no punishment here.
that you should look at the, because there's not a case cited by either of you, I can appreciate potentially why, right? Is
Right.
what is the impact of the actual financial status if there is a diminished financial status of the party to whom punitive damages may be sought again? Meaning, neither of you cited a case where the defendant was in bankruptcy or the defendant was, you know what I mean, no longer in business. I mean, we have a certain statute on that. Court may have signed an order with regards to statute in a CD context. I don't even about, you can't get the business after X number of years that it's no longer in business. So does that mean that you still would bring in punitive? I'm trying to reconcile this in light of the fact nothing directly on point. Go ahead, please.
You don't eliminate punitive damages when you file bankruptcy.
Correct.
We know that. Right. So their filing bankruptcy does not eliminate punitive damages.
Okay.
So now the only factors are what is relevant to the punitive consideration in this case. Financial condition or the deterrence. Okay? Now, in financial condition, if you wanted to play it all the way out, you would have to tell the jury that we've made offers of judgment, approximately $2.5 million. Assuming we beat those with punitive damages award.
No, I can't hear any of this because there could be costs and fees, and cannot take.
Okay, Your Honor.
If you're talking about a hypothetical case.
Hypothetically.
In a hypothetical case, I can listen to.
Okay, hypothetically, if we exceed the offer of judgment, the insurance company is going to be liable for the punitive damages. And that insurance company is worth 20, 30, 40, 50, it's a huge insurance company. So if you really wanted to explain to the jury where the punishment lies, you'd have to introduce the insurance company's financials. But we're not suggesting you introduce anybody's financials because financials are not relevant. The only relevance is deterrence. Okay, now focusing specifically on your question, what evidence would there be with regards to deterrence? There should be evidence of what the competitors are, and we've already got that in the case.
But I'm gonna have to ask you a question about that, right?
Okay.
I'm stopping you for a second because you have the unique situation here, Dr. Hutt, right? Worked for Young Brands. Young
Mhm.
Brands was a division of Pepsi, right?
Right.
Pepsi's one of the competitors. There was certain testimony that came in this particular case, two separate witnesses, right? Bush and Hutt,
Correct.
about how wonderful, I'm using the term wonderful. One, I think, called it a 10 out of 10. I think the other one
Mhm.
said that they were platinum, gold, or whatever, you know what I mean, the top of the other. So therein lies where the court's other question would be, is you're asking to kind of send a message to an industry that your very own evidence, at least a couple of witnesses have said, did things really
Just
right.
because there's good actors doesn't mean there's not bad actors, Your Honor. If you're sending a message to the industry, you don't have to drag all the bad actors in and parade them in front of the jury. So, for example, we don't have to drag the bottled water people that have arsenic in their water. There's 5 or 6 of those recalls in the last 2 years. We don't have to do that, Your Honor. We just have to show deterrence. And there's already evidence in the record. I mean, the business plan that Mr. Parker had up, I mean, it says right there that it's a $4 billion industry. It says right there that, that's a $4.1 billion or something or other. So there's evidence in the record as to how big the industry is.
But how is, where I was trying to go back to, right, is to punish, okay, I'm going straight from the language, the reason why I said page 5, right? The language here is reasonable, necessary to punish and deter the defendant and others from engaging in conduct. That's why I was asking, is this the exact proposed jury instruction? Because it does use the word and it says punish and deter.
That is accurate. I'm looking at the
Okay.
2018 Nevada jury instructions.
Okay, so you understand, that's why I was asking the and question, and that's why I stepped back, because remember, I don't have the proposed ones, that's why I said page 5, starting at the lines 8/9 through 16. That has the word and. So that's where the court's analysis was, when I was preparing for this, is punish and deter the defendant and others from engaging in conduct such that, right? So how would it, first off, do you all agree it's and or?
Judge, I'm looking at jury instruction number 24, and this is an agreed to instruction. It says, quote, punitive or exemplary damages are to make an example of or punish wrongful conduct. That's the agreed to instruction.
Okay, then folks, somebody needs to get me the instruction that you're asking me to rule, and that's the reason why I was trying to say, is it the page 5? If it was the page 5, that's what I'm going off of. If you all are saying that that's not the agreed upon one, then it doesn't really do me any good when you're asking me to rule on something that's not before me.
Well, Your Honor, there are 2 different instructions that are being referenced. The first one
I just
is.
need them, counsel, I just need them, okay? The short answer is, since there's a dispute over the language, right, in the brief it says you all are proposing the and, you all said it was exactly the same, just where you put the period on deterrence, that has and. So if you're saying there's an or, I just need to know what you're asking me to rule on. I think that's a fair request. Right, isn't it a fair request to get the
It is,
jury
Your Honor. I'm
instruction
trying to
asking me
get,
to
I'm
rule
trying to
on?
grab them for you.
Teddy, I don't
Two
think
different
that's,
jury instructions.
yeah.
That's what I'm trying to figure out what you're asking me to rule on, folks.
12.1 is what we had asked.
You understand a few moments ago, you all said the only difference was you put a period after the
That
word
is the only
deterrent.
difference in 12.1, Your Honor.
Okay, so that's the one you're asking me to rule on, correct,
Yes,
or
Your
not
Honor,
correct?
that's the one we're always asking you to rule on, 12.1.
So then what's plaintiff asking? That's what I said, folks, I need to know, please, whatever you're asking me to rule on, so I can make a well-reasoned ruling, please give me a copy of it. As counsels for plaintiff, you're saying it's an agreed upon 24, you're saying it's not agreed upon, and it's.
I'm saying it's not 24.
Huh?
Your Honor, Joel, did for we're saying it's not 24.
24 has been agreed.
It's been read.
It's been
But
read.
that's not the one we're arguing over.
Well,
Counsel, I'm only asking what you all are asking the court to rule on. Please give me a copy of what you want me to rule on. I can't go any further until I actually see what you all are asking the court to rule on.
It's
We are asking-
12.1.
Go ahead.
It's 12.1, we provided it, the town recall, I printed it out again, but I do not have a paper copy.
You can appreciate that the court did ask to make sure if I was going to rule upon it, that somebody provided it to me, because you both told me I wouldn't have to go digging through everything to find, because you were going to try and work on it, so.
My co-counsel has handed me a copy.
Okay, let's check with plaintiff's counsel and see if you're agreeing on what the language is of what you're asking the court.
Yeah, Your Honor, this is their tender jury instruction. We object to it because of the statement in here that,
So what is your tender jury instruction? Because you all said a moment ago, the only difference is after the word deterrence, you put a period.
Well, we objected to their instruction, that was the difference, Your Honor.
So what's your alternative proposal? I just need to see what you're asking.
Yeah, we can approach with the two different ones.
Sure, that would be helpful, so that I know what I'm ruling on, that would be wonderful.
Over each other.
Okay, okay, they both say punishment and deterrence, they don't say or.
That's correct, Your Honor.
The instruction number 24 that we've already read to the jury says punitive or exemplary damages are to make an example of or punish wrongful conduct. We've already read that to the jury.
You all are asking me to resolve 12.1, right, so I have to,
Yes, Your
Well,
Honor.
Your Honor, the dispute is, it's not an and or an or, it's whether the reference to the, in light of the defendant's financial conditions, that's what we're asking you to rule.
right, but the court was asking me a question, right? Because it makes a difference of what the purpose is, and is, right, conjunctive or is disjunctive, or gives you two opportunities and says they have to meet both prongs. That's why the court had to ask its question, which is why we got, okay? So, the amount of punitive damage will serve the purpose of punishment and deterrence, either period or taking into account the defendant's financial condition. But the and is there, and that's why the court was asking its question, is because the purposes, right, and it's plural, purposes, so that means you have to do two, right? It's punishment and deterrence, so it's not punishment or deterrence based on 12.1, which is what you're asking me to rule on. I appreciate, Mr. Kemp, you're referencing a different one, but I'm focusing on the one you're asking me to rule on. I appreciate that you're saying, well, guess what, something's already been read to the jury, judge, you want us to be consistent. Isn't that what you're saying?
Well, Judge, even if it's and, okay, and or is really not the big dispute here. The big dispute is in light of the,
Well, you have to take the rest of the sentence, you have to take into account the entirety of the sentence,
Right.
right? Pure structured language, realizing that jury instructions are proposed, they're not written in stone, they're not specific, and at least this one is not a specific rule of law straight out of a statute or straight, because obviously there's certain ones that are straight out of a statute. This is not one that's straight out of a statute. Or, and let me double check, the language of 42. Let's go back and check the language of 42, right? And I think somebody's bringing it up to plaintiff's counsel, and someone's probably going to be quicker than I'm going to be able to get on my computer. So, let's go to NRS.
Yeah, this one says an example. Oh, Joel, you see it? Joel.
NRS 42.
Yeah, I'm looking at 42005, I'm looking at the exact language, right?
It's close to this. Issue with this, and take a Okay.
Okay, interestingly enough, reading exact language, right, out of NRS, which I think you all just had the benefit of doing, right, the laptop that headed your way, that counts for defense, you've also had it, right? So you know I'm gonna go straight to the language of 42005, right?
I'm pulling it up so I can read it.
I was just given 12.1, Ron. I wasn't looking at the statute, but I can pull the statute up.
I think you're about to be given 42.005, which is why I'm pausing for a second. Voila, 42.005 magically appears, okay? Everybody have it on the laptops? It's amazing. Okay, so let's read 42.005, sub 1. Except as otherwise provided in NRS 42.007, an action for breach of an obligation not arising from contract, where it's proven by clear and convincing evidence that the defendant has been guilty of oppression, fraud, or malice expressed or implied, the plaintiff, in addition to the compensatory damages, may recover damages for the sake of example and by way of punishing the defendant, period. Except as otherwise provided in this section or by specific statute, an award of exemplary or punitive damages made pursuant to this section may not exceed, and you all don't need to read the subparts, that's the amount, that's not the, right? So, is there any other provision that 42.005 that either party wants the court to look at? I'll give you a moment in case you want to take a quick gander at that, right? Because the jury instruction has to be consistent with the statute. I'm going to pause for a second, figuring that you're going to let me know when you had a chance to review it. Y'all had a chance to also read subpart 4? Right, 3 and 4?
Yes, Your Honor, we have.
Okay. I'm just making sure everyone's had a chance to read it, because,
Yes, Your Honor.
okay, so. Okay. Commencement and subsequent proceedings. Okay. I'm going to give you all an inclination based on the statutory language, and then I'm going to give you each a little bit of time to argue it, okay? So, and the court has to, and remember, this provision has been around since 1995, based on what it shows at the bottom, right? So, and the reason why we're mentioning that is I was double checking the specific year of ACE.
ACE was 97, I think, Your Honor.
That's, pardon?
87.
87, okay. That's why the court was double checking the year, right? Because remember, first statute first came in, NRS 1989, that says modified, right, 95. Right there at the bottom of the provision, at least the electronic version I have. So, the court has to take into account the statutory language, and based on the statutory language, taking into account that a case that predates statutory language, and no one's provided this court any legislative history to say exactly what words have changed, okay? Then what the court has to go is, since 42.0051 says, right, for the sake of example and by way of punishing the defendant, and obviously it means plurals too if there's more than one defendant, so the court doesn't have an issue there. And then looking at subpart 4, where it says evidence of the financial conditions not admissible for the purpose of determining the amount of punitive damage to assess until the commencement, those two prongs leads this court by straight statutory language is that the taking into account the defendant's financial condition does need to come in by the pure statutory language. And the court cannot read these as separate between, quote, the punishment and deterrence. Now, the court doesn't have to go to a distinction in that language because you all agree all the way up to the word deterrence. So But since the statute itself says, by sake of example, and to punish the defendant, the court can't say that, and nobody's provided this court any any case law that says it's merely for deterring, okay? So I have to say the statutory language that says it's punishment. Now, when I take the statutory language, like I said, and then subpart 4, which talks about the financial condition, then financial condition does need to come in as part of the jury instruction. Now, it has to be addressed because we have a unique situation here, okay? Now, the question is, how does that get addressed? Because the language taking into account the defendant's financial condition, there's not a way, it would not be appropriate for an entity to be able to declare bankruptcy and to get out of punitive damages. That's a given, that can't happen.
I agree, Your Honor.
So what we have to find is how is a way to utilize the statutory requirements, right, which allow financial condition. In fact, it mandates it in sub 4, and the punishing concept, and make that in harmony with your jury instruction. And that's where I'm going, so that my inclination, I've given you the inclination with regards to what needs to be, right, that has to be considered, but I think the language as currently phrased, taking into account, could imply a utilization of the bankruptcy. That would not be permissible, although I don't really see Real Waters arguing that.
Yeah, if you're gonna tell them the financial condition, you have to tell them the real financial condition.
And therein lies the second
There
part.
lies the problem.
I was heading to that second part. That's why, if you recall earlier on, the court was asking whether or not, this is not the first time we've gone through the statute and applied it to where your all's potential issue is, but okay. So then that presents the challenge why the court was asking whether or not there was evidence of that $9 million, right? Because is that, quote, the evidence of financial condition, or in this case, is there not evidence of financial condition to be presented to the jury? The court needs to hear argument on that. Let you each have your positions. Go ahead, counsel.
There's two types of evidence of financial condition. There's Brent Jones's testimony that they did $9 million the last year they were in business, I think it was 2020. And then there's testimony by a lot of witnesses that they're bankrupt. So you can't present a false picture to the jury that this is a $9 million company, so they can only afford to pay $900,000 in punitive damages. That would be a completely false picture to the jury. If you're gonna let in financial condition, you gotta let in the bankruptcy, and then the jury's gonna ask themselves, well, why are we supposed to render punitive damages? And we'll just say it's to deter others. We're right back where we started. Okay, and I think we might even be in a better position, because then we can say, well, why does Real Water care if it's $2 billion? They're bankrupt, okay? See, so either you gotta tell them the whole picture, Your Honor. You can't have this $9 million weighed out as is the realistic financial condition without mentioning what happened in 21, 22, 23, and what is the current state of affairs today that they're bankrupt. And then you've got the additional problem that we've agreed not to go after them in bankruptcy for it, which leads you right, and confine ourselves to the insurance company, which leads right back to the can of worms I outlined, that now we've got offer evidence that the insurance company's worth $154 billion. So I think once you go down this fake financial condition road, and that's what they want to pretend to the jury that they're a $9 million mom and pop company, and so they can't be punished.
Is that disputed? Okay, counsel, here's where I need to go to that, right? That's going back to my initial question and my little hot dog cart example is that undisputed evidence the company's financial condition is $90 million? Is that by the parties disputed or undisputed?
That's the testimony of Brent Jones as of, I can't remember if it's 2020 or 2019, but we have no evidence whatsoever for 2022, 2023, 2021. We have nothing. So we don't know what their current financial condition is. So that's another problem, Your Honor. So like I said, you can't allow this, it's a charade. You know, they want the jury to, oh, we're a $9 million company. You can't punish us more than 50 grand or something, okay? When they're really in bankruptcy. So that's why I think you just can't go there. And that's what Ace Trucking says.
You each have cited Ace Trucking for two very different concepts on the annihilation and how it would come in. And see, remember, Ace Trucking dealt with the company itself. It did not address the insurance component by that company. Because
Right.
remember, you look at, and you can go more recently to some of the TEVA cases, right? The hepatitis, I mean, the court's only going to, I'm being careful that there's not a ruling, I'm just saying, is that when you look at it, you're looking at the actual entity. There's nothing that's been presented to this court that in a situation where it's been that you look to the underlying insurance
No, you're right.
company's valuation.
You don't, okay? You look at the company itself, if it's a viable entity. Teva's a great example. Teva was, I think, a $54 billion company. So they couldn't argue that they were going to be annihilated. If you recall,
The court cannot take any position on that. I have the opioid case, the court. If
okay,
you're talking
maybe
about,
they
if you're
took
talking about, I was
different
going back to hepatitis Teva. I wasn't
Okay.
going back to opioid Teva.
okay, but let's take a look at the defendant's position. They filed a motion to amend their answer that you allowed,
Of course,
and they added in the annihilation defense, the defense that's discussed in H. Trucking.
Sure.
They wanted to defend the punitive award by saying it would annihilate them. H. Trucking specifically says, quote, "The rule is available only in clear cases where the defendant is being wiped out." That is not happening here, okay? For the two reasons I've indicated. So how can they raise an annihilation defense to the jury under this case or any other case when they can't prove that they're going to be wiped out for the two reasons I've indicated? We've agreed not to even pursue the...
right, counsel, but the flip, right, which you're arguing, and here's why the court was mentioning Dr. Hutt's testimony, right, and Mr. Bush's testimony, is in looking at your page 6 under exemplary damages, right? And starting around line 15 to line 24, where you're talking about your expert report and how you want to compare it to multi-billion-dollar entities for purposes of punitive damages. This court, going to the evidence standpoint, has not heard that there's any evidence that, and I appreciate you've got the marketing report. The marketing report doesn't say real water has that market cap. It says overall the beverage, right, industry is 4.1 billion or whatever it was pretty close. So this court's trying to get an understanding. Are you trying to argue to the jury for punitive damages that the punitive damages amount should be taken into account as if real water was Pepsi or Carnation?
It should be taking into account the recipient of the message. Okay, the recipient of the message in this case are multi-billion-dollar companies like Coke and Pepsi. The court, I think, is conflating the size of these companies with whether or not they are good and bad. It doesn't matter if they're good or bad, you still have to send them a message.
No, what I'm trying to get a better understanding is what your argument is. When the statutory language talks about punishing the defendant, how you go.
Or making an example.
Sake of example and by way of punishing the defendant. I misspoke when I said or, I'm saying and. So it has to sake of an example for, right, that company
Right.
and. So it doesn't give the statement of saying you make an example of one company by doing it vis-a-vis other companies. That's what I'm trying to get an understanding here in this one. You've got a unique situation, trying to flesh out what each of your arguments are so the court can make a well-reasoned decision. Let me hear from counsel for Real Water. He hasn't had a chance to speak in a bit. Let me hear his position before the court makes a ruling. Go ahead, please.
Thank you, Under Joel Lee on behalf of Real Water. A couple of points, Your Honor. Ace Trucking is a 1987 case. That's the first point. That's critical because, as the court's aware, BMW came later, Philip Morris came later, and as part of the 12.1 instruction, it cites those later cases. So for the plaintiffs to say, oh, well, you know, Ace Trucking governs cases that came after doesn't make a lot of sense, besides the statutory construction issue. Your Honor, as far as the defendant's financial condition, we looked at this issue and we threw out the possibility. It's plaintiff's burden to make their case. So that's the first point. We threw out one piece of evidence that's out there, which is, and I'll just read it because I think the court's curious about exactly what did Brent Jones say. We've tried to boil it down, but Brent Jones' testimony was, up until this happened, and we were in with COVID, we went down, but prior to that, we were in the $9 million $9+ million annual for 4 or 5 years. That was the only testimony that we found where they talked about the pre-bankruptcy, pre-COVID financial condition of Will Water. We agree with the court, the financial condition of an insurance company, the speculation about an argument about bad faith rights and punitive damages against insurance companies and so forth. Those are misplaced arguments and they don't belong in this context. This issue arose before. We attempted to find other cases on this issue in Nevada or elsewhere, and we were unable to. And so unfortunately, it's a hard decision as to how do we handle the jury instruction, but it's pretty clear that the statute and the 12.1 pattern instruction say taking into account the defendant's financial condition. And lastly, I would just note the cases that we cited come after the case cited by plaintiffs. Plaintiffs cited an 87 case, we cite 88 case, a 99 case, another 88 case, and the 2 Supreme Court cases, which are, I think, 99 and full the actual dates. We are BMW versus Gore, 96, and then Philip Morris, 2007. What that goes back to, Your Honor, is plaintiffs want to send a message to the bottled water industry, and that's not in compliance with Supreme Court limitations, and it's certainly not in compliance with Nevada law. It's very clear that Real Water was a smallish company, and the punitive damages, when I say smallish and compared to Dasani or Aquafina or Fiji or any of these other billion-dollar companies. And to argue that they should be able to send a message to billion-dollar companies is just not proper, and it invites not only error, but it's also an invitation. They want to get a gigantic verdict to say, look at this gigantic punitive damages award that we got against this company. And that's not the purpose of the courts, to send some message to other companies.
Hold on a second. I'm taking a look at Wyatt is the most recent of the cases cited in the jury instructions. I'm taking a quick look at that language. Give me a second, please. It's a 47-page opinion, so it's going to take a moment. What evidence of financial condition would each side, I need an offer of proof, would each side proffer with financial condition or at issue with regards to jury instruction? And then I'm going to ask you the same question if the court did not include those couple of words.
And Your Honor, first of all, it's their defense, it's the annihilation defense. So the burden's on them to prove the defense. So the only evidence of financial condition that we have are the $9 million, the ones that's been alluded to, and the fact that they're in bankruptcy. Those are the only 2 big pieces of evidence of financial condition. So if they're gonna say that they're just a $9 million mom and pop, we're gonna have to say that they're in bankruptcy and they're not on hook for this. I mean, that's just what's gotta be said.
Okay.
That's the evidence of financial condition that they filed bankruptcy.
If you're saying that it goes for the purposes of punishment and deterrence, it's the second question, then counsel of defense, I'm asking the same 2 questions, right? The counsel of defense, if you say the jury instruction ends at the word deterrence, what are you asserting you can tell the jury?
We're asserting we can tell the jury that for the sake of example, and again, that's directly from the statute, for the sake of example. It doesn't say for the sake of example to small companies. It doesn't say for the sake of example to mid-sized companies. 42.005 says, quote, for the sake of example, unquote.
Right.
So I think we're entitled to put up their business plan, show their reference to the 4.0 billion, whatever it is, and just have the jury consider what award needs to be given an example in the context of that industry.
So how do you get to the industry? And the reason why the court's asking that question, right, is you read part of 42.005,
right.
1, but it's right, and may recover damages, I'm doing it after the comma, right, in addition to compensatory damages, may recover damages for the sake of example and by way of punishing the defendant. So it's not just sake of example for a broader, right, a qualified defendant at the end of that sentence. And so I'm trying to see if you're saying those are disjunctive, conjunctive, or what's your position?
Your Honor, the Nevada pattern jury instruction specifically says, quote, deter the defendant and others, unquote. It's not just deter the defendant, it's deter the defendant and others.
And you understand and appreciate that Nevada pattern jury instructions, right, are developed and they, I mean, we're not gonna go through that, but even at NJA stuff, they went through some of the pattern instructions which no longer are applicable under changes in law, et cetera, right? So pattern jury instructions cannot be relied on for court for law. In fact, I could cite you a couple of cases where the Supreme Court has said that recently, one in which I am personally aware of. So the court has to look at the basis by which the pattern jury instruction was developed, which that means I have to look at the statute. I'm hearing what you're saying in the pattern jury instruction.
Which is not just a pattern in jury instruction, they agreed to it. This is the stipulated instruction between the parties, deterrence and others. They agreed to this.
Sorry, so you're going to number 24 now versus 12.1?
24.
No, this is 12.1. This is the jury instruction at issue.
But they're not agreeing to 12.1. Otherwise, I wouldn't be here having to make this ruling. If you all are stipulating, that makes my life very easy, folks.
Your Honor, we stipulated to the entire instruction except for the line that says taking into account defendant's financial condition. That's the only issue. They want to say, leave that line in there and parade the incomplete Fred Jones testimony of $9 million. We say, because you're bankrupt, financial condition is irrelevant and there's no need to even get into that, and the focus is on deterrent, because there's no amount of money that's going to punish them.
1 second.
There's no excessive punishment.
Okay, let me circle back. Defendants, do you concur that the rest of the jury instruction was agreed upon by the parties as stipulated? So the only thing the court is looking at is subpart 2, starting between lines 18, 19, after the comma, the words taking into account the defendant's financial condition.
Your Honor, that is what we've asked the court to address, taking into account the defendant's financial condition. Plaintiffs removed it from the instruction. We think it should be there. We think it has to be there. They're raising a tangential issue about arguing about punishing the industry. Well, that's objectionable for a different reason, but that's not what we're arguing over right now.
The reason why the court has to ask this question, right? Because part of your bench brief, right? Your citation to BMW, some of the other cases, right, cited in the section in your bench brief, says the focus specifically on the defendant, whereas if you all have agreed already, which sounds like you have, that's a new fact presented to the court just a moment ago, and realistically, you all get more than one horse and rider because I've gotten 3 on the other sides, but since you haven't asked for it, okay, but you get the same, okay, is if the court's not looking to the language and others engaging in conduct, then I'm not going to address that, because if you all have already agreed to that. And so that's why the court has to have that understanding first. And what I'm hearing you both say is you have agreed to everything other than subpart 2, after the comma, taking into account the defendant's financial condition. Is that correct?
We have objected to taking that language out. That is correct. If the court is asking us if there's some type of waiver because we're objecting to language that they're taking out, I disagree.
No, okay. Honestly, I'm trying to find out the flip of it, right? If you all have I heard Mr. Pepperman say, indirectly I heard Mr. Kemp say, and I saw Mr. Parker point to it, okay? So I have a trio of the Plaintiffs' Counsel, right? Apparently contending that the concept of deter the defendant and others, the basically and others issue, which goes to the industry concept, has already been conceded by real water, whether you want to use the term conceded, whether you want to use the term stipulated, whether you want to use the term not objected to. Basically, that it's outside the purview of what you're asking the court to rule on because the parties have already agreed to all the rest of the language. That's just my simple, is that accurate or not accurate?
We do not waive the Philip Morris case, Your Honor. We cannot waive a constitutional right in by saying and others, now they're trying to inject a different issue into this argument. They're trying to say that somehow Real Water has waived the right to object, that they want to punish the entire industry because the prior line said and others. And that is against the United States Constitution, due process, and the Philip Morris case.
Okay. But if you all have already agreed to it, then it's not before the court, and they don't have to make a ruling on it.
This is true.
That's why this court was asking the question, did you all agree? Which I don't think I've actually gotten a full answer. I hear plaintiff's position that yes, their understanding is it was all agreed to. So what I'm doing is if I hear one thing from one side that says there's an agreement, I check with any other party to see if that's accurate or not accurate, so that, remember, the lovely crystal ball I have doesn't let me know what's in you all's mind, doesn't put me behind the scenes. So only you all can tell me whether there was or was not an agreement. Counsels for plaintiff have told me there was one, is that correct?
That's correct, Your Honor.
So now I have to ask counsels for defense whether, I just need an answer to this one before I move on to the next part of the issue, right? I mean, I'm hearing you're very eloquently talking about how you can't waive something, but do you understand my question is a little bit more simple, and it's just, did you all agree, right?
And Your Honor, I think all we're asking for is for the 12.1 instruction to be read as it is in the pattern instruction, with that final clause included about the defendant's work.
Okay. Should I take that to be, Mr. Love, that if the instruction had ended at that you've agreed to every other part other than those words or not? That's really what I'm trying to get an understanding. I'm trying to get an
I
understanding.
don't see and others in the 12.1, that's what we're saying, Your Honor.
It's right
Okay,
there.
counsel, I'm looking at what's D3, okay? You handed me,
And we're looking at the pattern instruction, and apparently plaintiff may have modified the pattern instruction and added and others, and now the court's calling our attention to it. I'm not seeing it in the pattern instruction.
counsel, I'm actually looking at, so we're clear what the court's looking at. I was handed defendant's proposed special and jury instructions objected to by plaintiffs, cited, okay?
Right.
Yeah, that's the document I'm looking at. And so the one, thank you, you followed all the nice little rules, the D3 in the lower right-hand corner on page 7. That's the one I'm reading from, okay? I'm not reading from plaintiffs, I was actually reading from defendants because I thought that was the easier way when I was asking defendants the question. Now, realistically, you both have that same language, okay? The P6 appears to be the same as D3, but for the language that goes after the comma, subpart 2, which is the last 7 words of the instruction. Otherwise, they appear, I'd have to double check whether there's an S on plaintiffs and defendants, but otherwise they appear to be identical. So, if you've agreed to everything that is prior to the taking into account the defendant's financial condition, then the only issue before this court is taking into account the financial condition. And then the court has to find that even if there's language in the statute, since it's not contrary to the statute, it's a modification or an interpretation of the statute by agreement of the parties, I have to really ignore, and ignore, don't use it in the wrong sense. I'm just saying I do not have before me to rule upon anything other than part of subpart 2, which starts on line 17. So if that's the situation, then I have to focus back onto the aspect of whether there's a per se requirement to include financial condition, which I'm understanding is defendant's concept that it's per se needs to be, versus plaintiff's perspective that if you talk about financial condition, you have to be full financial condition, which could lead you down a potential path of having to go into the bankruptcy, which would not be appropriate to go in front of a jury. So
We
you
are
all
not
basically,
waiving our bankruptcy defenses, Your Honor, that is true. We object to that.
okay, so you understand. Once again, I really appreciate excellent lawyering, who's the moving target of this. We're just trying to hone in on what the court's ruling on. Okay, so this court now has to look at the concept of, in this particular case, if the language taking into account the defendant's financial condition is included in the instruction, then that have to say that there is some evidence that's going to come in on defendant's financial condition. And so then the court would have to ask, in the standard financial condition, you have to use up-to-date financial condition information to present to the jury. You can't present things that are years old. Both sides agree to that concept?
Yes, Your Honor.
Did you agree or disagree?
We disagree, Your Honor. Your Honor, bankruptcy is not to punish a defendant.
I think you're missing.
That's the next step that the court is going to, which is giving us the choice of either waiving our bankruptcy or taking and using the language or taking the language out. And
But you can read my
that's a
mind, but you're
Hobson
wrong.
choice.
But you're wrong, counsel, you're wrong.
Okay.
You're incorrectly reading my mind.
I'm not trying to read your mind, Your Honor. I just am concerned that there is some request by the plaintiffs to waive our bankruptcy defense, and we are not doing that.
Here's what the court's really looking at from a practical standpoint. First, I have to see what's the actual issue before the court. You now clarified to me that I don't need to look at the rest of the instruction because the only thing I'm dealing with is subpart 2 after the comma, starting with taking into account. Then I have to look at that. I have to look at the fact that a jury instruction is not specific law. A jury instruction is a compilation of various people's viewpoints put into it, and you can look at the difference in the two sets of pattern jury instructions and how different they are, and how some of those pattern jury instructions are no longer accurate statements of the law because of subsequent case law, subsequent changes in the legislature, you know.
Right.
Okay, so a jury instruction is a jury instruction is a jury instruction. It has no greater impact. But agreements of parties means I focus on a certain part of the jury instruction. So then I have to go to the part of, is it required to include the financial condition? In this particular case, when there is a bankruptcy, we're going to have to look at the fact that in a standard case, including the Wyeth case from 2010, which is the most recent case cited on 12.1, and all the cases you all have cited, whether it's before the changes to the statute or not, okay? When I look at all of those cases, they all did take into account, with a caveat on ACE, right, the financial condition of the defendant or defendants, okay? Now, the annihilation concept is, in taking that into account, can you get a verdict so large that it will annihilate, or is that something else that needs to be added? But that still starts with financial condition, okay? But none of those are bankruptcies. None of those are a situation that's been presented to this court that the only information with regards to the financial condition of the company is several years old historically, okay? You all would agree with that, just the factual aspect, right? The factual aspect, you agree, okay. So then this court has to say, look at the fact of, okay, in light of that, is this a case of first impression for the concept? And I appreciate we're the second trial, but technically, right, you argue it differently, and I don't know what you argued before Judge Williams. I intentionally did not know, do not want to know, and only what you all have presented in your various comments here in court is the only enlightenment I pretty much have, okay? So I don't know what you argued, and I don't know what he ruled. But that being said, I now have to look at this kind of case of first impression is, in a situation here, when if you were to include the language, take the financial condition, and that means the jury would be able to take the financial condition, is what information can be presented. If I were to take a case of a punitive damages, I'm going to take a default to make my life really easy on an example. In a default under Foster v. Dingwall, I know the standard's different, what could go to jury, but in a default when there's punitive damages concept, oftentimes the other side has not presented the financial condition, right? So you have to look at a punitive damages award based on the only evidence that's presented, and does it meet clear and convincing, does it meet Foster v. Dingwall, does it meet the standards of the statute, okay? There you don't have financial conditions presented. There's not been anything I'm aware of where the Supreme Court has found that it is a constitutional violation or it's impermissible to award punitive damages on a default when the parties chose not to participate, right? And so you don't have financial condition. So I'm trying to look for examples to see if in every case you've always had to have financial condition or not, because that's how the court's gonna have to look at this case, is to see if it's a per se requirement, or do you have to look at it on a case-by-case basis. It appears to this court I have to look at it on a case-by-case basis. It's not a per se requirement, because once I mention defaults, it kind of eliminates the whole idea that it must be required, otherwise every default that had punitive damages would per se be impermissible, and we know that's not the law. So that means you have to look at it case by case. Then you have to look at this case, there is a bankruptcy. Can the concept of a bankruptcy come in on a punitive damages? You both agree it can't. I know counsel for plaintiff says it would have to, and I may have an understanding of why they say that. I can't read their mind, but Mr. Kemp's articulated various reasons, okay, that he thinks it would need to come in. Mr. Odou said the bankruptcy can't come in.
We say it can't come in, and we analogize it with the Capriati construction versus the Bobby case from 2021. That's the problem.
Okay, so next step is the bankruptcy can't come in. So the true actual financial condition of real water can't come in because there's some case law that implies in a somewhat different context that a bankruptcy issue cannot come before the court. And that would be consistent in most cases, and the reason why it rarely comes up, would make practical sense, is because not every case is there a lift stay. So if there is a bankruptcy proceeding, absent a lift stay, you're not even in court dealing with the issue, and so you're not really dealing with the bankruptcy. And otherwise, you're making claims in the bankruptcy, and I appreciate here it's a different situation that you all have made a stipulation in bankruptcy. So now we have to walk through the next step is the bankruptcy issue cannot be presented. So the true financial condition of real water cannot be presented to the jury. So then I have to go to the next step of if the true financial situation of the real water cannot be presented to the jury, is it accurate to say to the jury, you have to take in defendant's financial condition, when by definition they can't take in defendant's financial condition because of the bankruptcy, which leads me to the fact that I have to rule in favor of plaintiff and not include those words. Okay?
We understand the court's ruling.
I appreciate people always agree and disagree, that's the point of litigation.
It is.
I'm just trying to give you the best explanation of where I have to come from that situation because there is no case law on point. And otherwise, a bankruptcy would have to come through the jury in order for it to be an honest and accurate picture of defendant's financial condition. And the $9 million is a historical, several years ago historical, and it's not as if it was a recent bankruptcy. So you could tell me, well, these are 2023 numbers that can come in. Your number is 2019, is it not, my recollection?
It is, Your Honor, and the only thing I would add,
Sure.
and I understand the court's ruling, the only thing I would add to the record is it's the most rosy picture. In other words, it was the company at its height. And so it was the best years of the company. Now, again, it's in the past and it was pre-COVID. That's the only evidence that could be offered because of the bankruptcy, and we understand the court's ruling. I just
No,
I
I'm
need
trying to make
make that clear.
Yeah, no worries, I'm trying to let everyone say whatever you need to say for whatever purpose you need to say, okay? But even taking the 2019, this court is aware, remember other people's testimony, and take when Mr. Bush and other people were and were not at the company,
Right.
different standards. So you're telling me as a matter of argument that Brent Jones is saying that's the rosiest picture?
Brad Jones is saying that's the rosiest picture, and the only point we would make with that is that it seems that real water is penalized for being in bankruptcy, in that financial condition will not be weighed against an ultimate punitive damages number. In other words, the plaintiffs could argue for the sky's the limit, whereas if real water had been in business, they couldn't have.
Okay, but just to let you know from the court's perspective, the reason why the court doesn't see that as far as being a disadvantage, because once again, it's been presented to this court that the only aspect of 12.1 this court is to rule on is subpart 2 after the comma.
Correct.
But there already was an agreement with the rest of the language. So how that is interpreted is really by agreement of the parties. It's not subject to a court ruling. I'm not saying that plaintiffs can do X, Y, Z.
The court is
really-
not, and I'm
yeah.
not trying to imply that.
No, I know you're not. I'm just saying, when I look at, are you being penalized for the bankruptcy? The reason why I don't see that you are is because bankruptcy is a neutral factor, right? Not having the true accurate picture, bankruptcy or not bankruptcy. It's really the same, going back to the hot dog vendor, right? As if no one, or a default situation, whereas if no one presented accurate, up-to-date information, which is true in this case. You don't have accurate,
We do not.
up-to-date information. And so I don't see it being harmed, because if you had accurate, up-to-date information, and that was being presented to this court as being, quote, the defendant's financial condition, then that would be considered, but I don't have anything to, quote, consider as defendant's financial condition other than 5 years ago information, which is, no one's told me is substantiated, which is also, I'm not weighing the credibility of that, but you all just told me, and I appreciate your offer of proof that Brent Jones is going to say that, but nobody's telling me that there's even any support for that.
Correct, Your Honor, that's correct.
So-
The company being out of business, there are no financials. I mean, every document that does exist has been made available to the plaintiffs, but That's all we have.
And I appreciate what you're saying, in no way is the court saying that you didn't provide everything. I'm just saying, I have to look at it. Is this ruling fair and equitable and consistent with applicable law, taking into account what's been presented to this court as the narrow scope of what you're asking the court to rule on? This court feels it is, that's why I said it, that's why I've explained it for so long. So final ruling is 12.1 comes in with a period after the word deterrence. Okay.
Thank you.
So, thank you so very much. Okay. I remember the court's not implicitly saying that you can argue other things. I'm just making that narrow ruling because that's the only thing presented to the court. Is there any other narrow rulings that you all need while we're waiting for the jury to deliberate, counsels?
That's it from, I'm sorry, that's it from the plaintiff, Your Honor.
Joe Odou for Royal Water. We're grateful for the court investing the time in this. We appreciate it. Thank
No
you.
worries. Okay. What the marshal's gonna do is probably in about 10 or 15 minutes, check with the jury as we told the jury that he was going to do. So I'm not sure if you realize or appreciate it. We're now at the 4:26-ish hour. And so do you all, if you want to stay here, you're more than welcome to stay. The marshal, like I said, is going to check in around 15 minutes to see if they want to stay past the 5 o'clock hour and how long they want to stay past the 5 o'clock hour. There usually is a general hard stop somewhere around the 8 o'clock hour if people want to, just because of the overtime components and various other issues. Does anyone have a disagreement if we put 8 o'clock as a hard stop and then they come back tomorrow? If you're all proposing something different, let me know.
Your Honor, so they would come back tomorrow at 8:30?
I could offer them 8:30, 9 o'clock, whatever time they want to
I
come.
don't know. Because I remember you said something earlier about 10 or 2 tomorrow. That's court time, right?
There's been a variety of different changes, as you can appreciate in this. So we're working the best we can to accommodate everything, even if things get canceled that need to get canceled. So trying to take care of you and every other case on my docket.
Thank you, Your Honor.
So I appreciate your concern, thank you, but the answer is yes, they could come back at 8:30, yes, they can come back at 9. Where I really kind of wanted from you all is oftentimes attorneys do not wish the jurors to be past 8 o'clock because remember, they have, well, we can ask a marshal to escort them down to where the jurors park and things like that. It presents a different issue, and I'm sure you're aware of some cases where jurors can't be asked to go super late at night. Now, whereas I have a wonderful team that's more than glad to be here, we need to know what the attorneys are requesting, if anything. Go ahead, please.
Your Honor, in terms of the plaintiffs, whatever the jury prefers to do, I've been here waiting for juries at 1:30 in the morning, so whatever, not suggesting anyone else to do it. I've done it, but whatever the jury prefers to do, we're in favor of. We're willing to stay around as long as they're willing to stay around.
As you can appreciate, there's been some more recent case law about asking jurors.
We're not asking.
Okay. And so that's why the court is finding out what the counsel are asking of the jury to do. Do you want a hard stop time? Do you want to let them do it as long as they can, subject to whatever issues there are for overtime and court facilities? It's not me. I'm here. Anybody who knows me, you know, you can see sometimes when you get orders signed. It's not exactly like I'm not 24/7.
That's correct, Your Honor. We'll go to Plan B. Whatever the jury decides they would like to do, we're willing to accommodate that.
Counsel for defendants?
Still for the Royal. That's fine, Your Honor. You know, we wouldn't mind a hard stop at 7 or 8, just in case we do have to come back for another phase. It would make sense to not stay too late tonight, because if we're coming back, we're not.
And that's,
Your Honor, I thought one of the jurors had like a hard stop at 4:45 for child pickup.
that was one of your, during the voir dire process, we did have that issue.
I can't recall if anything made it onto the jury. I thought they did.
That particular person did not. Do other people have various childcare issues? Yes, but that's part of the reason why the court asked you all if on Friday we could let the jury know that it was likely to go to the jury today, so that, remember, you may remember that the court said to the jury so they could make whatever arrangements they needed to make with their families, et cetera, in case they chose to stay late. That's one of the reasons why we do that, to try and take those into account. So we're not adversely impacting members of our public to the extent possible. So that's one of the reasons. The other reason when my marshal checks with them about 4:45, because if somebody does have that issue, they can just generically say, guess what, we want to come back tomorrow, can come back at X time, okay? And then the way we just would do that is I would stop it in the middle of whatever I am in my morning motion calendar. We have a verdict and call you all in, and then if there is a second stage, then we would deal with that as well. And it's part of the reasons why there's no longer a conflict tomorrow afternoon, is just in case or take care of you all. Okay, that being said, is there anything else at this juncture? Shall we go off the record, counsels or plaintiff?
Yes, Your Honor.
Off the record's fine with you, okay. Counsel for defense, off the record, is that what you mean?
Thank you.
I appreciate it, thank you so very much. Okay, everyone will go off the record. Welcome to stay in the courtroom, not stay in the courtroom. Okay, we're on the record outside the presence of the jury, which is deliberating. When the jury has indicated to the marshal that they wish to be done for the evening, they wish to come back tomorrow morning at 9:30 and continue to deliberate. Does that meet the needs of counsels for plaintiff?
Yes, Your Honor.
Does that meet the needs of counsels for defendants?
Yes, it does, Your Honor, thank you.
Okay, so then we have two problems going after that question, okay. A, I presume you all have gotten together, if there's going to be, not saying there is or is not, a need for what other additional jury instructions. You are taking care of that tonight, right? Checking your captions and getting that fine-tuned, correct?
Yes, Your Honor, I'll have additional potential jury instructions and verdict form tomorrow.
Okay, that is- okay, that part, just the detailed part of it. The next part of it is, I will be in the midst of a pretty lengthy motion calendar tomorrow, so we will be balancing that with my motion calendar. So what we'll try and do is we get a verdict. If we get a notification of a verdict, you all have left the phone numbers of those phone numbers and the individuals the same for tomorrow.
Yes, Your Honor, Joel, I do for real water. I left my cell phone number and.
Okay, meaning, I just didn't know if you're switching, if you're passing the torch to somebody else tomorrow.
No,
Okay, staying with
it'll
you?
be me and I'll send messages to the rest of our team.
Okay, thank you. And on your side, did whoever,
That's fine.
Okay.
We keep our number.
okay, so you're fine, you're not passing the torch to anyone, okay. So we've got that part taken care of. And we'll just work out the rest of the timing for tomorrow. The next thing is your alternate, the one alternate who's currently staying. Do you wish him to come back tomorrow and just sit by himself? Or would you be okay that he's already been read the admonition, that he is able to go to work, but that he has to tell his work that, you know, in regular times, he has to check his phone, like probably around 9:30 and maybe like on an hourly basis or something? Are you gonna request that he stay here and sit here?
Your Honor,
I'm fine with that, Your Honor, just as long as, where does he work again?
bus driver, isn't he?
Yes, he is a bus driver. Remember, we have certain confidential information which doesn't get,
Right.
and remember, we're in a public forum, so I'm trying to be conscious of everyone's right. So, yes, he's indicated he's a bus driver, so he normally does not keep his phone on because he can think of that for safe, he didn't say safety reasons, but he
I
said
would
normally.
suspect, with what little I know about bus drivers, I would suspect that if he's not there at the start of the shift, that, you know, he's unavailable, so probably better to have him come in. I don't know if plaintiffs wanted to excuse him, but I'm willing to talk about it, but it just seems like he probably has to come in.
From the marshals, from my understanding from the marshal, there's no reason to believe that any of those jurors would not be able to come back tomorrow, subject to nobody having a crystal ball of what could happen between tonight and tomorrow.
Yeah, I would just want to make sure that the alternate calls in at 9:30, so for example, if one of the 8 has some sort of unanticipated problem overnight, we can get him in here right away.
Nobody asked him to call in at like 9:15, 9:30?
Whenever the jury's gonna come back.
Okay, I can ask him to call in at
That's
9:30.
fine.
Does that meet your needs? Or do you want him to come and sit here
I
tomorrow?
don't think he needs to come, just as long as he calls and he can.
Yeah, as long as he can get back if he is needed. And then it just, I'm not clear on his work, and if he goes into work, is he stuck? That's kind of the question I was getting at.
I'm hearing what you're saying. You can appreciate my JEA asked a limited question. I mean, they offered everyone pursuant to you all that they could either leave with the admonition or they could stay. He just indicated to her that nature of his job, he couldn't, quote, be readily available for phone every, 15 minutes or whatever he said in the courtroom. But is there any reason? That's fine. Let me. here's the other question for you. Or you could treat him as being attendance and not physically having to come in, but then he would not go to work, but he would be viewed as still being on our panel and subject to coming in. As you can appreciate, if somebody is
I think
released
that's-
back to their job, they release back to their job, they need to go back to their job. If somebody is being viewed as they are still here and required to remain completely available, if that's a request of counsel, then the court could accommodate that request and view him as still being here, and whether you wish him physically to sit here in the courtroom, or he specifically agrees that he will be available by phone all day, then
Available by phone would be fine with rural water, Your Honor.
Just ask if he's getting paid by his employer, because.
I don't know the answer to that. I can, if you all request my JA, I can go and ask him. But I would do that only if I had you all's joint request to do so. She can go ask him.
Mr. Pepperman says he's Clark County, so he would be getting paid, so if he's getting paid, that's what you might want to be here. Or be available by phone.
Yeah, that's fine with us. I don't know that we need to ask him, but if you want to ask him, I don't have an objection to it. I would join in their request if that's what they want to do.
If he wants to come in, Your Honor.
Okay.
I don't know if he's indicated preference.
My understanding is that he's trying to diligently do his duty as an alternate juror, and that if he goes into work, at least that by the nature of his job as bus driver, he can't keep his phone on, and you might have practical reasons that you can anticipate why he couldn't keep his phone on. So my understanding is he has just raised that as a thing, which is why he stayed today, and that he indicated if he goes into work tomorrow, then he will have to have his phone off pursuant to policy, is my understanding. And so that is the limitation of what this court's aware of. If you want further questions asked of him,
No,
Then-
Your Honor. I'm back to the old position, which was having him call in at 9:30. Me and we'll drag him in.
but then I need to know if you all are treating him as if he is still for attendance of jury duty. He is not released to go back to his job. He needs to maintain and have himself available at basically 10 to 15 minutes notice to come in.
Yes, Your Honor.
Yes, Your Honor.
Okay, that's what we'll tell him, and then he can make the choice whether he wishes to come and sit here, or he agrees that he's home available, or some other location within 10 to 15 minutes. Is that what your needs?
It does, Your Honor,
It
thank you.
does, Your Honor. Thank you.
So if the court doesn't have a preference, that's whatever you all wish to do. We just need to treat him as either having attendance because he gets paid as a juror, or he gets released back to work. That's what I just need your clarification on what you all wish. And I understand you want him to be treated as still having attendance as a juror since he's the first alternate. That's correct or
Yes,
not
Your
correct?
That's correct.
Is that correct, counsels for plaintiff?
That is correct, Your Honor.
Okay, well then, that means from your all's end, I'm going to wish you a nice relaxing evening. Let me tell the marshal first that the jury can go out. Can you, while you're getting your stuff together, can you wait a few moments so we don't have deliberating jurors in elevators with counsels and witnesses and clients?
Sounds
Right.
good, Your Honor.
So let me ask the marshal to come in here after the jurors in the elevator, okay?
Thank you.
Good head start, appreciate it, thanks so much.